Okay.
I got Velda and Boston.
I was David Barker.
All right, we'll look at it.
This is the callback.
And we'll take it up. Sure.
Remember where we stopped.
Just 1 second, I'll be able to grab my handy notebook and we'll see. Okay, just give me a moment. Sure. Oh, no, I'm good. I'm just gonna find this document for him.
See if there's a deal. Yeah, you know, a letter that he met with the immigration lawyer.
Who are you looking for?
Luis Fernando Guion.
I don't have that one. All right, are the parties ready on David Vargas? Where's David? All right, where's? Yeah. Yes, has the information been uploaded? Okay. All right, so if you all have stepped back a little bit. All right, we're gonna go on the record. In 2018 CR 5087, State versus David Rodriguez. And if you all will re-announce, please. All right, and are you Mr. Vargas? All right, so you had entered pleas of true to number 1, and it's driving while license invalid. And also to a violation of condition number 2, consuming alcoholic beverages. All right, and probation is leaving it up to court as to what to do with your cases. All right, I'll hear argument.
You know, we're asking for revocation. You know, I thought earlier this morning, this is secondary felonies. I know the court has read the steps from that case, but the facts are really bad. The victim says in the steps that she heard, and after he killed her, he threatened her, threatened his own brother with a knife. So apparently a scary offense. He gets deferred on that charge in 2018, and he hasn't been doing the right stuff since he's been on deferred, Your Honor. He's got a pending DUI. He pled true to drinking alcohol while he's on deferred, Your Honor. So we are asking for revocation at this time. And if you are not inclined to revoke him, we would ask for status and aftercare, which is a previous recommendation of probation, or at the very least a jail sentence. You know, this is these are very serious offense that he's on for adjudication, and he's not doing the right thing. This is what he's still pending. The DWI is inherently a dangerous offense, Your Honor. It's dangerous to the community. It's dangerous to himself. He also had folks in the car when he was driving, so apparently dangerous there. That's why we're asking for that.
All right, defense.
Since this all happened, heard from your CLO, he had no value. He understands what he did with his previous. He not have the blood results back on the DWI. I believe that the difference for but we believe Your Honor, he admission him on the vehicle that is probation. That he understands the mistake he made.
All right. So I understand that the state is talking about what's in the stipulations, but really what we're here on is he drank alcohol and he picked up a DWI. So here's the thing with regards to your request, you're going to get a choice. You're either going into inpatient treatment, either way, you're going into custody today. You're either going into custody for inpatient treatment, and I know there's a pending DWI, and you're going to be waiting until that DWI is resolved, or I will sentence you to 4 years in the prison. Okay, he doesn't seem like he wants it. He's sort of like,
No, it's just, I'm just having your time. I figured at the beginning of this, when I first put on probation, I did while I sat in this for 2 months waiting, I took classes, like reading classes in there. I found out that well, I found me at church. I do a meetings, I do more than the required. I'm trying to figure it out.
no, I understand, but here's the problem. And I will tell you, with regards to the stipulations, that's potentially be considered if you're going to prison, like what would be appropriate. So, I mean, you're going into custody today. You're either going to, I'll let them consider maybe felony drug court will accept you. I don't think they will for the nature of cause, due to the nature of the cause, but yeah, you're not going home today. So if you want treatment, you'll be going into treatment, or if you want prison, you'll be going to prison. So which do you prefer? I'm sorry. Okay. All right. And I will note that you've actually been on probation since 2019. And this is the first motion to revoke I've had with you. All right. So I'll deny the motion, alternate amend conditions. To include SATA. Well, we'll start with to include a referral to felony drug court. And that's to be in custody. If felony drug court doesn't accept him, then SATA. And he's to remain in custody until transfer. Is there anything else? That's Judge Glenn. Yes. Okay. Okay. All right. Yes. Okay. Yes. Yes. All right. Thank you. Oh, they'll do an application. Yes, you may be excused. Sure. All right. And everyone, just give me a moment. Just 2 minutes. I'm gonna check in the back to see if I can find that file with the exhibit numbers.
I think that's the. Wait, when they quit after that, I think, no.
I'm gonna go about 6 months. Again, order, but he's gotta get the, he does not finish. And I'll be able to-
And can I see the file on Meyer, please?
Yeah. I did. And it was- without that. Well, I'm kind of really got. Yeah.
Counsel, I think the court reporter may have my notebook. So she is actually in the 186th District Court. So if you go there, she'll be able to tell you what the last exhibit number is. Yes, because I don't think we entered anything, well, 100 may be too far. I don't think we entered anything into evidence alphabetically, did we?
Do we do letters then? Ken?
Yes. And then you know what? Let's do it this way. Enter it as P1, because P stands for punishment. And so you can do defense is P1. We'll label it that way. You're welcome. All right, who is here on Guillaume?
Court guidance.
All right, so he's,
He's in
Yes.
custody.
come down, hello. So what is the issue?
The issue is that the deal, we have worked out a bargain, let it go. This was referred to the PD's office,
Mhm.
January. Nothing is, no letters been produced. And as far as I can tell, it was referred, I think, to the MAC, because the lady that was doing it has left the office.
Okay,
So we got referred, and I've been calling the MAC today to see what the status is. Haven't been able to hear anybody. So he is aware that he's gonna be deported. He's spoken to someone who explained everything to him. I think it was probably the lawyer, but he was gonna tell. And I don't know if the court wants to.
who did you speak to?
It was the immigration lady there, and then somebody else, and his name was Andres. And then they told me that my rights, that I'm not gonna get deported for Mexico, so yes, I understand my rights, and I'm not gonna get deported. And they were just telling me how they watch the border, like, I'm like, yeah, I'm from Mexico, and I'm just trying to get this everywhere and send it, if y'all can send it back, and they're like, we're just waiting for the courtroom, to decide what you're gonna do with you, and we wanna take you back. So I think they would keep, at least on the team as soon as possible, they will pick me up and send me back to Mexico.
All right, so you understand that you're going to be deported? Okay, all right, you all can proceed. He's already talked to an immigration attorney.
Thank you.
You're welcome. You're welcome. All right, if you'll have a seat, they'll.
Thank you.
All right, who's here on Linda Flores? Are you on Linda Flores? All right, court is calling 2024 CR 0492, State of Texas versus Linda Flores. That party is announced for the record for the state.
Casey Garrett,
Defense.
Brian Kimbrough, of course.
And are you Linda Flores? Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Flores, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Oops. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Flores, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance penalty group 1 gram to 4 grams? That's a third-degree felony.
Yes, ma'am.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, court does not have to follow that plea. If the court does not follow that plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, The court could find you guilty, sentence you up to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine probated. State recommends deferred adjudication, and there's a request for a drug court evaluation. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State.
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, and no contact with Gilbert Vega. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plea?
No contest.
State, any evidence?
Yes, Your Honor.
No objection.
All right, you may continue to confer. Showing you the waiver and consent to stipulation of testimony and stipulations document. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Would like to, Your Honor, yes.
Anything you wish to say on behalf of your client?
I would like the court to follow the plea bargain. I believe this is a first felony. I've had a long talk with her. I believe she can complete her probation successfully.
All right. How old are you?
I'm 36.
Do you have any children?
Yes, I have one son. He's 14.
And where's your son?
He's with my mom right now.
All right. Was Child Protective Services involved?
No, ma'am.
All right. And if you're released, where are you planning on staying?
With my mom.
Does your mother want you there?
Yes, ma'am.
Did you pick up the phone and ask her, or are you just assuming?
No, I live with her.
No. Here's the thing. My question is, did you pick up a phone and ask her if you could continue to live with her?
Not recently, no.
Okay.
To be honest with you.
Because here's the thing, the 14-year-old is underage. Your counsel does CPS. They'll tell you it's not a good
Your Honor.
deal for you to be there.
If
Yes.
you give me an opportunity to show you that I can complete these probation with the drug monitoring, I can complete it. I'm very driven and ambitious to show you that I could be successful at what I'm trying to.
When did you start using?
It's been like since last year, since I
Why were you using?
depression, mental abuse.
Why were you not with your mom?
I was with my mom, but around that time I was in the streets when I had got caught. So I just recently moved back with my mom.
All right, what's your mom's name?
Brenda Herrera.
All right, when's the last time you had employment?
It's been so long. I'm on disability, on SSI,
For what?
bipolar manic depression.
All right, this is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication. There's a $500 fine that will be probated. There should be a TAP evaluation in custody. There's to be a referral to felony drug court in custody. And if she's not accepted into felony drug court, then I'm going to want her brought back to court and we'll see what the TAP evaluation says. There's to be no contact with Gilbert Vega. Who is Gilbert Vega to you?
He was my ex-boyfriend at that time. I don't have no contact with him at all since that last prior time that we had got arrested together.
There's to be proof of employment or SSI
Yes, ma'am.
within 45 days.
Yes, ma'am.
There's to be no employment as a home health care provider or with minors. You are not allowed to reside with, I'm sorry, with Brenda Herrera. There's to be no unsupervised contact with minors. There's to be 120 hours of community service restitution. I'm going to require parenting classes. Once she completes that, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. There's to be the UA hotline with testing every 2 weeks. Field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court?
I have a question, Your Honor.
Yes.
I've had contact with some of her family. I can't speak to whether I talked specifically with the mother. I may not have, I may have, I'm not sure. But if her mother wants her and is okay with her living at home and wants to approach the court or contact the court on that basis, will the court entertain modifying that order?
After she's completed somebody's inpatient treatment or completed time with felony drug court. And then if you're in felony drug court will make that decision. But here's the thing, the reason why I'm saying no contact or you're not allowed to reside there is because you have a 14-year-old there. And if your son is 14, which you're telling me is, and I believe that, that means that you were with this Gilbert Vega person while your son was on the planet. And instead of being at home doing what you were supposed to be doing, you were out using drugs with somebody else. That's not good. And then what I find ends up happening is that people will then go back to their mom's home and then act like they're in charge of a child that they haven't been raising. So yeah, no. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Where you are now,
And my,
you're just doing improvements, right?
yes, ma'am.
Nobody's perfect. Everybody, me included,
I'm trying to get it.
are
together.
trying to get their lives together and do improvements. So just know that where you are now, hopefully this is not where you're going to end up. You're going to improve your life. You're going to get clean and sober. Okay.
Yes, ma'am.
All right. Good luck to you.
Thank you.
Is there anything else?
Thank you.
All right. Who is here on? Oh, you need me?
Just for.
Okay, sure. Yes. Hello. All right, so where are we?
Yes, Your Honor. First, court setting today. My client has expressed the desire to get some drug treatments. He is charged with some allegedly possessing some controlled substances. I did reach out to Bear County Population Impact Control Unit to see about getting him screened for potential inpatient treatment. And we'll see where we can go from there, Judge. My hopes is that possibly probation offer with some inpatient upfront, Judge, but I did go ahead and refer him. So my hope is to get him evaluated to see if he qualifies for some inpatient.
All right, so have you received all of the discovery?
At this point, yes, Your Honor.
All right, was an offer tendered?
Yes.
All right, Ms. Ferguson, on this case, let me see. If we can get a plea deadline date. How long is it going to take you to figure out?
They usually are pretty good around the 2-week time frame to getting him screened, Judge. So I would say anywhere like 3 weeks and after would be.
All right, Ms. Ferguson, can you call this back for the 21st or either the May 20th? Yes.
Yes.
All right, so we'll bring you back on May 20th. All right, good luck to you. Yeah. All right, on George Hawkins,
Yes, Your Honor.
yes.
I will be on him on his case as well.
All right, so what are we doing with this?
Yes, Judge. With regard to him, Your Honor, he's a previous veteran of the Navy, honorably discharged. He does have some issues with some substance use as well as mental health, Judge. We would respectfully request the opportunity to have him screened for veteran treatment court. I did give some of his collateral information to John Herman already. He apologized and said he couldn't be here today. But he said that they would have no issue screening him to see if he's eligible for possible services through the vet court, Judge.
All right, so does he already have his DD 214?
Yes, Your Honor. And I got that over to Mr.
I knew you would.
Herman.
All right, Ms. Ferguson, on this case, can we set it for May 28th? All right, we'll come back on the 28th for a status.
Yes, Your Honor.
Is that a good date for you, counsel?
Yes, it is, Judge.
Yeah.
All right, thank you.
Thank you.
Kevin Yates. Kevin Yates?
You mean, Judge?
Oh, sorry, Kit
No, that's
Yates.
all right.
All right, what is happening with this case?
We were conferring, I was just beginning conferring with Mr. Yates. He seems to be doing much better than he was the last time.
Okay,
And I just began talking to Mr. Garahan, who's reviewing the case extensively, re-reviewing. It's been a while.
okay. So what are you all asking for? Do y'all need some time?
I would think so, yes. I'd like to be able to talk to Mr. Garahan. I'm sure he'd like to be able to put together his offer. That's what I think he's attempting to do, but we've been on hold for a while because Mr. Yates has been on hold for a while.
All right, so we're gonna have to bring this back fairly quickly, and the reason why is because people decompensate. I can either do it the week of April 29th, if that's enough time for everybody.
No, that'd be fine. We need to decide exactly the direction to go, so that will give us way enough time to make a decision on that.
All right, Ms. Ferguson, on Yates, and I'm sorry for calling you Kevin. It just seems like
Okay.
Kevin Yates flows with that.
It's okay.
All right, no, I should get your name correct. Never let anyone get your name wrong and don't correct them. All right, Ms. Ferguson, can we do it April 29th or the 30th? All right, so we'll be back on April 30th, all right?
Sure.
All right, thank you.
Just remember Kent from Adam 12, right? What was that
I
name?
remember Adam 12.
Yeah.
seat, sir.
Yes, yes, I didn't realize you. were here.
All right, and could I see the parties on Guillaume? And if there's anyone else who's ready, have your file put up because after this, we're going to take up Mr. Meyer. Court is calling 2023 CR 11242, State of Texas versus Luis Fernando Guillon Hernandez. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Brian Kimbrough for Mr. Leon Hernandez.
And are you Mr. Guillon Hernandez?
Yes, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Guillon, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Your Honor, we're gonna waive count 1 and count 3, proceed on count 2.
No objection.
All right, Mr. Guillon, did you understand that in count 2, you're charged with fraudulent use of possession of identifying items? And it is less than 5. Did you understand?
Yes, Your Honor.
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you're bargaining for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Guillon Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
No.
Counsel, was your client advised of the consequences of entering a plea and this cause number and the impact it will have on his immigration consequences?
He was, Your Honor. We spoke about it a number of times and we did have a attorney that I think specializes in immigration law speak to him about it. Correct? Is that correct, Mr. King?
Yes, sir.
And so he is aware of that and wants to go forward today.
All right, Mr. Guillon, are you aware by entering a plea of no contest or guilty in this cause number that there will be immigration consequences? Immigration consequences
Yeah.
from entering this plea?
Yes, yes.
You understand
Yes, I
that by
understand.
entering a plea in this case,
Yes.
the consequences could be deportation,
Yes.
the denial of naturalization, and you may not be allowed to re-enter the United States. Did you understand?
Yes, Your Honor.
And did you speak to an attorney who
Yes.
specializes in immigration law about
Yes.
this case?
I did, Your Honor.
And what is your understanding?
Well, they was telling me my rights, you know, like as a illegal immigrant, and then like telling me that I understand. They said that I'm gonna get deported, you know, as soon as I get done with this. I say, well, thank you, you know, I understand they're gonna deport me, so I really I tell them that I want to go back to Mexico, you know what I mean?
Okay.
Even if my kids are from here, and I tell them I'm sorry, you know, I apologize, but I was just working as a responsible dad to take care of my kids, so.
Okay.
I understand what the consequences is, Your Honor.
All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yeah, Your Honor.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 1 year in the state jail facility. Did you understand?
Yeah, Your Honor.
Is that the plea?
That is your honor.
Is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yeah, Your Honor.
Did you sign it in both places?
Yeah, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah, Your Honor.
Counsel, are there any such motions?
No, your honor.
Then to the offense as charged in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, state office.
No objection.
Showing, you may continue to confirm, showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yeah, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yeah, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yeah, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, your honor.
All right, the court will sentence you to 1 year in the state jail facility, give you credit for any time served. There's to be no contact with Cesar Sanchez. And there's to be no reentry to the United States. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yeah, Your Honor.
All right, good luck to you.
Thank you, and you have a great day.
All right, you too.
Thank you, Mr. Brown. Thank you so
All
much.
right, can I have all of the files that are remaining? Mr. Porter, are you ready on Pete Garcia?
Judge, they were gonna bring that out. I was just explaining what's going on. Judge, what's with the year and a half.
Okay,
And then I'm gonna go by the jail. and visit about some cases.
all right.
He should be.
Mr. Vargas, could you all keep him here for a moment, please? And is Pete Garcia coming out?
Yeah, that's, yeah.
I just didn't let him sit there all day long without.
All right, and when did we recall Stevie Ray Stokes for? Okay. And then Roxanne Ava. All right, Angel Pacheco, that was reset for April 16th. That's on page 8. Deputy Lord, did y'all already send back Angel Pacheco Martinez?
Yes, Judge, can we talk to, Stateson?
Yes, so that's for April 16th.
Yes, he was here.
Yes. All right, and where is Anthony Wilson? All right, recall that for tomorrow. Yes. And is this council appointed? Okay. All right. So recall that for tomorrow and tell that attorney he needs to be here. And he's in custody, Deputy Laura.
Yes.
All right, Paulo Lara. Paulo Lara. All right, could I have a prosecutor, please? Court is calling 2024 CR 1302, State of Texas versus Paulo Resendez Lara. Sorry, off the record. Norma, this is set for April 18th. That's on page 10. Yeah, that's supposed to be here on the 18th, not today. All right, State, I do need you all on Tricia Harrison. All right, court is calling. No, she's a no-show.
Sorry, Judge.
Oh, no problem. Court is calling 2024 CR 0452, State of Texas versus Tricia Harrison for the state.
Hank Wilkins for the state, Your Honor.
All right, the defense counsel in this case is Abelardo Garza. He informed the court in the presence of the state off the record that he has no contact with his client and that his client is on a PR bond and that no telephone contact numbers were given to the PR bond persons. This hearing was scheduled at 9 a.m. It is now 3:23 p.m. and the defendant has not made an appearance.
We're asking for a judge's warrant, Your Honor.
Hey, John.
All right, that'll be granted. And the defendant will be remanded without bond. If the defendant makes an appearance, the court will reconsider.
Thank you, Judge.
You're welcome. All right. Roxanne Alva. Is she in custody? Is Roxanne Alva in custody? ALVA?
No, Your Honor.
All right, why is this set today? I don't see it on the docket. All right. Adriana, can you look to see if that's on the docket today? Oh, she's not on the docket?
No.
Okay,
2023.
all right. All right, after we take up Pete Garcia, then we'll take up your case, on Mr. Meyer.
Let's ask you a question.
Yes.
Mr. Meyer, do you wish to have him give a sample today, urine sample?
Is he ready to do a UA?
He can just do one or the other. He can go either go out to the restroom or give a sample, whatever you'd like for him to do.
Are you able to do a UA? All right, yes, we'll do a UA.
Okay. We did one earlier, but the results were sent to us and it's kind of vague. It says negative, but I want to go ahead and maybe have a confirmation for you.
All right, thank you. You know me so well.
Yes, ma'am.
Judge, I don't think the test was vague, was it? Just the printing of.
The printing of the test was
Mark, you want to make sure that it is not a appearance that it's positive for something.
That's right.
Judge, may I approach when you have a minute?
Sure.
I apologize for my appearance. I didn't anticipate coming down.
Yeah, you have to have anticipated coming down.
They needed you to write on the B page that it's okay to take his monitor off.
Okay, I thought that was already done.
I
All
thought
right.
so too, Judge.
I'm gonna give you this, but I think we already did a form
Okay.
in the back. But all right, if you'll take it into the back.
Will do.
Sure.
I got a email from Ireland and the UK.
I'll come, let me come talk to you in the back just a second.
I have to head back real quick.
All right,
That's the greatest thing.
yeah, I'll talk to you in a second. Are you going, you can go to the back. All right, Norma, just give me 2 minutes. All right, are you all ready to go, Mr. Meyer?
Yes, ma'am, Judge, we are.
All right. Oh, please, remain seated.
Okay, thank you.
Sure. So, Mr. Meyer, if you want to come up. Yeah. Deputy Laura, on this case, they say they have 5 witnesses.
Okay.
Okay. Okay, I'll take care of them. Sure, no problem. Oh, but Sean, you may want to get that file back from the clerks. Oh, the court's file?
Yes.
Okay. All right, the court is going to call 2024 CR 0170, State of Texas versus John Stephen Meyer. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Charlie Baird and Mark Stevens for John Meyer.
All right, and are you Mr. Meyer?
Yes, I am, Your Honor.
All right, the court is in receipt of a PSI report. Have parties had a chance to review the PSI report? State?
We have, Your Honor.
Defense?
Yes, ma'am, Judge.
Any objections to the PSI report?
No, Your Honor.
No, ma'am.
All right. So we're here for sentencing. The defendant was found guilty by a jury of count 1 on January 29th. And the PSI, of course, we know the PSI takes 6 to 8 weeks. So we are here now. I think originally the PSI was set for March 25th. And then we were in jury trial, so it was rescheduled for today. All right, State, do you have any witnesses?
We do, Your Honor. State calls Jerry Lorkovich, Your Honor.
If you'll take the stand, please.
And we would invoke the rule, Judge.
All right, the rule will be invoked. Is there anyone here? All right,
There's not, Your Honor. I'm sorry. All my witnesses are outside.
okay. All right. Can you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Jerry Lorkovic,
All right, and how do you spell your last name?
Lorkovic.
All right, state.
Thank you, Your Honor. I'm Mr. Lorkovich. My name is Hank Wilkins. We've met before, but thank you for coming out here today. Where do you live?
I reside at 220 Majestic Grove in San Antonio.
And is the defendant one of your neighbors?
Yes, he's my next door neighbor.
And how long have you lived there?
My wife and I had our house built in 1997.
And how long have you been living next? When did the defendant move in?
I met John, his wife and his 3 children when they moved in. I believe it was the summer of 2012.
And did he have his family living with him?
He did, his wife Vanessa and his 3 children.
And were y'all friendly?
Sure,
You know each other's names, you know each other's families, that sort of thing.
yes.
Okay. And did his wife and kids, do they still live there?
No, in 2017, his wife told us that she was being transferred
Here's
to,
that, Joe.
Sustain.
I'm sorry, you can't answer. If there's an objection and the judge sustains,
Gotcha.
you can't answer the question. So, does the defendant's wife still live with him?
no,
And what year, how long has his wife and children not moved next to you?
I believe it's since 2017.
And what's your neighborhood like? Is there a gate there?
There is a gate. There's a total of 47 houses in the neighborhood.
Okay. And how close are you to, is there a school nearby?
There are 2 schools nearby. At the end of at the gate of the subdivision across the street is Hardy Oak. I'm sorry, it's Lopez Middle School. And then there is Hardy Oak Elementary, which is across the street from that school.
Judge, I'm sorry, I can't hear with.
All right. So if y'all could whisper in the box a little bit, and if you'll make sure that you speak up
Sure.
into the mic so everyone can hear. Okay. Just a whisper. Thanks again. All right. If you'll restate your last answer so that the defense can hear.
Yes, there's 2 schools on Hardy Oak Drive, which is at the beginning, which is at the gate of the subdivision. Lopez Middle School is across the street from the gate, and Hardy Oak Elementary is up the street across from Lopez Middle School.
Okay, how far is it a far drive? How long would it take you to get there?
2 minutes is less than a mile.
And you told me that when did the defendant's wife move out of the home?
I believe it was 2017.
And did you notice unusual activity at the house after that?
Not right away. Probably the summer of 2018 is when we started noticing different things go on. We noticed there were multiple people that had moved into the house. We also noticed that all of the windows in the house were covered. And then there were cameras that were put up on 3 corners of the house.
And when you say covered windows, can you describe that for us a little bit?
All the windows, including the front door, there's 2 side windows. They were covered. There's also some windows above the door, and I believe there's some half moon windows above the original windows that were all covered.
And when you say people moved in, do you know who moved in? Did you meet them?
Did not meet him. There were a handful.
And did you notice unusual traffic coming and going from the house?
Yes, there were multiple vehicles. Some would come and for short periods of time. Others would be parked overnight.
And why was that unusual to you?
It wasn't, it's unusual only because we didn't know exactly what was going on. Didn't know the reasons for people coming and going. When John's wife moved, it was my understanding that John was going to stay there and do work on the house to get it ready to sell. And it didn't appear that any of those or many of those were having to do anything with construction.
And did you ever wake up with somebody on your front porch related to all this?
I did. I believe it was in September of 2018. I have a camera that alerts my phone on my front door. I believe it was 5 o'clock in the morning. My phone alarmed me. I went and looked at it, and there was a girl that I recognized from coming in and out of John's house that had 2 backpacks and was sitting on our front steps, having a conversation with, I don't know who, but she was talking to herself. Then she moved the backpacks and leaned them against our front door. At that point, I got up and asked her what she wanted. She said that,
Sustained.
So you can't tell us what she said, but how did you feel about that?
a little unnerved. Not sure why somebody would
Excuse me,
be.
I'm sorry, just a second. Okay, all right, you may continue.
A little unnerved to have someone that I didn't really recognize sitting at my front door early in the morning.
Did she seem intoxicated to you?
Yeah, she did.
Did you see, was that the only intoxicated person you saw coming in and out of the house?
It was hard to tell, but she definitely was.
What about vehicles? Was there weird vehicle traffic over there?
Yes, there's several times where vehicles would come and go. There's another incident where it was in the evening. I heard someone raised voice coming from outside. I went and looked. There was a girl probably in her mid to late 20s or 30 years oldish that was outside in John's vehicle. It was a pickup truck. And I believe she was talking to herself. When I went out to see what was wrong, she was trying to dig at and get inside of the dashboard of this vehicle. I believe she believed that her son was in there.
Was there other unusual activity going on at the defendant's house?
Yeah, coming and going again. Different cars that would stay for short periods of time and then leave. Some people would stay overnight. Yeah.
Did you ever talk to your neighbor about it? Tell them you were concerned, or?
No, we didn't speak a whole lot. But I'm sure that other neighbors voiced their opinions.
Were you ever afraid based on living next door to the defendant?
Yeah, sure, the fear of the unknown. I know that there were 2 different instances where Bear County came in and raided the house. So that made us a little unnerved, not knowing what exactly was going on or what was going to happen next.
And why were the cameras unusual to you?
In my career, I worked for an armored car company, and the cameras were very similar to the ones that were used to protect for security in our vaults. They weren't necessarily your Ring cameras. They were much more than that. 2 of those cameras pointed directly towards our house. One in the back corner that would point basically towards our pool and our patio area, and the other one on the front of the house that would the front corner that would point towards our house and our patio and our front door-ish area.
And so did you have any concerns about your property value doing some living next to the defendant?
Sure, we're in the process right now of looking to to move. And the concern I have is if we are asked about our neighbors and we have that obligation to disclose what's been going on, I feel that that may be a problem with us selling the house and or certainly not getting as high value as we'd hoped.
You're not afraid of Mr. Meyer hurting you though, right?
No, no.
Are you afraid of somebody else hurting you because you live right next door?
You never know what goes on. And that's, we're probably more afraid of the unknown, and just without so many people coming and going, that you just don't know what's going to happen.
Thank you. I'll pass the witness, Your Honor.
Right, defense?
Mr. Walker, what do you do?
I'm retired.
Retired from what?
I was in the transportation industry for several years.
And you built your home out there in 1997?
Correct.
And then about 15 years later, Mr. Meyer moved in
I believe it was,
and was there, you think, with his wife, and do you remember how many kids he had?
he had 3.
And did you socialize with them?
Occasionally, yes.
And would you come to his house and he come to your house, that type of thing?
I know he's been to our house the night before his wife Vanessa and the children moved. We had them over for dinner. My wife would watch their dogs, and so yeah, there was some cordial back and forth.
I take it that if he came over with his wife and kids, that you knew that they were about to leave. Was it kind of a going away party?
It was.
Were other neighbors there as well?
No.
Just the 2 families?
Yes.
Yours and do you have a wife and kids?
Yes, I do.
And did you have a wife and kids back in the 2012 when he moved in?
The same wife, yes.
Okay. And how about your kids? Were they raised over there as well?
Yes.
Are your kids about the same age as John's kids?
No, my children are older. They're all out of the house. They're in their mid-30s.
And you said this is a gated community
It is.
and there are 47 houses there?
I believe that's correct.
And or you said that there are 2 gates,
There's one gate.
1 gate?
And
And
then
how do you get in and out of the gate? Do you have a guard there? Do you have a combination? How does it work?
you either have a code or you could do a code on a keypad, or you could use, a lot of people have an automated, like a garage door opener that
Like
will.
a fob or something?
Yeah,
So a code or a fob or it's never just left open, is it?
when it malfunctions, it'll be left open.
And so if I was going to go to your house and see you, and I would call up and you give me the code and I could punch in the code and
Yeah,
get it open, is that right?
yes.
Thank you. You said that after his wife and kids moved out, that you began noticing some unusual activity in 2018, is that right?
I believe that's correct, yes.
And you mentioned before that you said John was going to do some refurbishing or some work on his house. Did you understand the extent of that or what was going to happen?
I believe I was told that he was going to do some minor repairs and some painting.
Right. And did the people that were coming and going, the people that was, do they appear to be some of them in work trucks and doing some construction work over there?
There was one work truck. There was also like a Penske rental vehicle.
And do you know if the rental vehicle there was for moving people in or people were moving out, or do you know?
Don't know.
And you know that there were other people that were living there other than John, correct?
Yes.
And you said that there were like a handful of people. Do you know if did they move in 2018?
I believe it was the summer. There were a couple that had moved in then.
Okay. And did you meet them?
I did not.
After John's wife and kids left, did you ever meet anybody that lived in them?
I did not know.
You said you thought there were about a handful of people that had lived there,
Yes,
and was it the same people that lived there from 2018 or 19, whenever they moved in until, do you know how long they lived there?
I don't.
Did they all have vehicles?
I don't believe so.
Do you recall how many vehicles were typically outside?
It varied. There were usually, at that time, probably 4.
So a handful of people and 4 vehicles. Did John have a vehicle?
Yes,
Do you recall what kind of vehicle he had?
I think he had a pickup truck at that time.
And you knew John did some construction work as well, didn't you?
Could you repeat
Did
that?
you know John did some construction work as well?
I knew I don't know if he did construction. I knew he was doing some repairs on the house.
I'm sorry. Did you know that he did that as an occupation?
Oh, no, I did not.
Did you understand what his line of work was?
I didn't know that he ever worked when he lived there.
Did you know what his wife's line of work was?
She was in the military.
And do you know that she and the kids moved when she got transferred, I believe, to Virginia? Did they tell you when you had the party and it was kind of a going away party, did they tell you that she had been transferred and she was moving?
Yes.
Okay. Do you recall where she was moving to?
The DC area is all I remember.
And you mentioned that there were, John had some cameras on his house. And then you mentioned that you had a Ring camera at your home, correct?
It's not a Ring camera. It's similar. It's I believe it's Argo, but it's a camera that points at the front door and will alarm if there's motion.
Okay. Did you have any other cameras at your home?
Yes.
Okay. And were any of those cameras directed at John's residence?
At one time there was, yes.
And was John aware of that? Do you know?
Yeah, it was more of a to get his attention so that he had talked to my wife about taking, and my wife asked him about the cameras and he said he was going to take them down and never did.
And so you put up a camera or two toward his property?
Yeah, it didn't record. It was just a box of a camera.
Did John know if it was working or not?
I don't know.
You mentioned an incident with a girl, a young lady on your porch. I believe you said that was December of 2018. Is that right?
I don't know if it was December or September, but I believe it was 2018.
And was there a time where John borrowed your phone to call the police?
He did.
And was that to have them come out and take that girl or another person off of his property?
I'm not sure yes, he did request to use my phone to call police to have someone removed. I'm not sure who that was.
And you mentioned that when Mr. Wilkins asked you if you were afraid, you said that you were kind of afraid of the fear of the unknown.
Sure. With all the people coming and going, you don't know who's coming in, who's going. Certainly was with the 2 times Bear County came in there and raided the home. That's a little unnerving.
Let's talk about that for a second. Were you at home both times?
I believe I was on my way home, the first incident, and the second one I was home, yes.
And were you on the first incident? Did you arrive when the police were still there?
Yes.
Okay. And did you go out and talk to the police?
The first time I did, I don't believe I did.
And the second time you think you did?
Yes,
And those were the only two times that the police were out there at John's house, as far as that type of situation was concerned?
yeah, the police were out there other times, but I'm not sure for what. But those were the only two times for that
And
situation.
that's what you said was most alarming?
Yes,
Okay. And those occurred fairly close together, correct?
I believe, August and November of 2022.
Yes. And you understand that those are involved in why we're here today?
Yes.
After John's wife and children moved out, did you continue to have a social relationship with John?
Not really.
Did your relationship just kind of fade away, or just, would you wave at each other? Were you mad at each other? Well,
No, I mean, if I saw him, we'd wave, but there was no social interaction.
no more you going to his house, or him going to your
No.
house, or anything like that? Did y'all do anything else? Did you borrow his lawnmower, or he borrow your lawnmower, or things that neighbors might do once in a while?
No,
Okay, just really no interaction.
right.
Did you ever go inside of his house to see what was going on as far as refurbishing or fixing it up?
I did not.
When you were at your home, could you hear construction? Could you hear hammers and saws and things like that?
Not really.
When you say not really, what does that mean?
Well, then, no. Yeah.
And what is the distance from your home, feet wise, would you say, or yards wise, football field wise, from your house to John's house?
Maybe 50 yards. We all have an acre of land. All the houses in the neighborhood. And most of them are set in the center of the property.
And I guess you're like all of us homeowners, you're kind of worried about your property value, you want to make sure it stays high, correct?
Sure.
Then we'll pass the witness.
Just real briefly, Judge. I just want to make sure I have it straight. Were you most alarmed by the police coming out, or were you most alarmed by the foot and vehicle traffic and the activity going on?
Well, the foot in the vehicle, all the activity going on. I guess the police showing up and raiding the house was a result of all the foot traffic and the comings and goings.
Okay, thank you. No, I pass the witness, Your Honor.
Any follow-up?
Just have to say this.
Sure.
I had just moved there. Going back to the gate code and the fob and all that we talked about before, do you know if John had some type of configuration so that he had to go let people in physically at the gate?
I'm not aware of that.
Not aware of that?
No.
Pass the witness, Judge.
No further questions for this witness.
All right, is this witness excused?
Yes, Your Honor.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state or the defense.
Good.
Thank you. State, call your next witness.
State calls Deputy Jorge Salazar. I'll go get him. real quick.
Sure.
Okay.
I'm sorry, Jorge Rios.
Thank you.
You bet, appreciate it.
And Judge, we have agreed to excuse Mr. Lorkovic from the room.
All right, thank you.
You mind if I step back real quick?
Sure, no problem.
Could I address the court too, Your Honor?
Sure.
Now that Mr. Wilkins is back, we believe that the next 3 witnesses or 4 witnesses will all be testifying about physical evidence that was seized at the property. And it's our contention, Your Honor, that this evidence was seized in violation of the 4th and 14th Amendments, Article 1, Section 9 of the Texas Constitution, Article 38.23A, and 1801B of the Texas Code of Criminal Procedure. So we prepared a memorandum on that. We would like to make an oral objection to any evidence at this time, and we can object as we think it's coming in. Would the court like us to orally argue that motion? Can we give it to the court for consideration? We can do whatever the court wants us to do.
Well, I don't know what he's here to testify about. So once I hear that, then you can make your objections, because I don't know what the motion to suppress would be about. I don't know if this is related to a search warrant. It's related to the same search warrant that the court has heard before, or is this related to something different?
It's a different search warrant, Your Honor, but Your Honor is correct, I think, in thinking, is it a 4 corners argument? And that's exactly what it is. It's a 4 corners
All
argument.
right, could I,
Yes, ma'am, I have one. Sorry, I didn't mean to cut you off, Judge.
oh, no problem. So what I'll need to see then is you all can offer the search warrant,
I'll do that.
and then I'll review the search warrant.
Your Honor, could I say that we will offer this for the limited purpose of challenging the search and not for the truth of the matter that's asserted in the affidavit, because it's hearsay and it violates our right to confront and cross-examine. So we'll offer Defendant's Exhibit P13, Your Honor, and Defendant's Exhibit P14. 13 is the affidavit. Again, we offer for limited purpose under Rule 105, just for, not for the truth of the matter asserted, but for, so we can make a challenge to the 4 corners of this affidavit.
Okay.
And may I offer as just an exhibit, Your Honor, for lack of anything better to call it, our objections.
All right, so let me see the actual affidavit. And if you all will also offer the actual search as well. If I can see the affidavit and then what
the
was.
search warrant?
Yes.
Yes, Your Honor.
So if y'all will label those two, and since both parties state, are you saying the information that Mr. Stevens wants to give to the court is just related to the 4 corners of the document? There is no challenge that what the officer said is what he said, correct? We're not going on whether something in the exhibit is false. Am I correct? We're just looking at the 4 corners?
That's right, Your Honor.
All right.
Could we supply the court with our objections, Your Honor? Our
Oh,
written
just one
objections?
second. Let me read this verse. All right, so the court is accepting into evidence without objection from the state.
No, sir.
All right, defendants P13, and if you all will give me a moment, I'll review it. You can mute us, please. All right, officer, if you want to wait outside for a moment.
Yes, ma'am.
Sure. All right, the court has had a chance to review Defense Exhibit P13 and P14, and the court will hear argument. Oh, you can remain seated, or if you would feel more comfortable standing, that's fine. But if you remain seated, it'll be easier for the court reporter to hear. And
I'll
if you'll
talk
just-
loud, Judge.
Okay,
Judge, there's three things I'd like to say about this affidavit. And they go in sections. Section number 1, paragraph number 3 of the affidavit makes the wholly conclusory statement that the premises are under the control and charge of John Meyer and known to be occupied by Theta T. Reyes. We'd object to this, or we would note in terms of our objections that this is a wholly conclusory allegation, which is not attributed to any informant at all. So it should be considered for nothing. And there's a case we cite on page 3 of our, on page 2 of our objections. May I give the court a copy of these objections?
yes.
And
And
I'll
is
give-
the state
I will give,
in receipt of the
Mr. Wilson.
objections?
yes.
Thank you.
Your Honor, I've just handed the court a document entitled Objections to Admission of Evidence Obtained as a Result of the Unlawful Search and Seizure at 224 Majestic Grove on November 1st, 2022. So that's our first objection that I just made along the lines of the Casillas case, and it's found on page 2 of our written objections, Your Honor. Next, we note that this affidavit really falls into two separate events it's talking about. Event number 1 is in the paragraph, 6th paragraph, Your Honor, of the affidavit, beginning with affiant did on or about 10/26/2022. So we'll call that the October 26th incident that purports to state probable cause for this search. But it doesn't. So the problem, Your Honor, is it says that on or about that date, 10/26, the affiant received information from a credible person, a confidential informant, quote, concerning narcotics being possessed at the above location by Theta T. Reyes. That tells us nothing. Specifically, what it does not tell us, Your Honor, is when did this informant, this confidential informant, acquire the information? So we hear that the confidential informant conveyed the information to the affiant, but when did the confidential informant receive the information? That matters. Did the confidential informant, I say receive, I should say acquire the information, because that's another problem. But when? Or was it a day before it was passed on to the affiant on October 26th, a month before, a year before? It's important to know, because incidentally, Your Honor, this search was not executed until November 1st. So we have a passage of 5 days or so between the time the affiant said he received it, but we don't know when it developed. We also don't know not only when, but we don't know when the confidential informant claimed he saw Theta Reyes. By the way, he didn't say he saw
she saw John Meyer in possession of any narcotic, just the Theta T. Reyes. Now, so that's vague enough as it is, but it gets even more vague, Your Honor, because narcotics are not against the law. You can get prescribed narcotics, and it doesn't even allege that the narcotics the confidential informant saw at some unknown time. And by the way, at some unknown time. So was it one prescription Dilaudid that she had in her possession? And what would that say, by the way, if we knew a time when it was seen, allegedly, if we knew that, what would that say about the likelihood of methamphetamine? Because that's what this search warrant claims to authorize a search for. What would we know? What would it provide a fair probability that there was methamphetamine at the residence on November 1st when it was actually searched? For all those reasons, Your Honor, we state that this affidavit is that event number one is completely insufficient. And what was the basis for the informant's information? So we usually see that the informant saw, it'll say the informant saw within X number of hours methamphetamine possessed at a certain location by a person. It doesn't say what the basis of the informant's information was. When, it doesn't say how much. So it in no way states a probability that there would be drugs, that there would be methamphetamine found there on November the 1st. Event number two, does that add anything to it? Far from it. I tried respectfully to describe this event number two as incomprehensible, because I think it is incomprehensible. It's very difficult to know what it says. But we know that event number two is not event number one, because it says within 24 hours of today's date. Well, so we got 3 dates that are important here. The first date is event number one, Your Honor, which is October 26th. The second date is October 29th. That's the date that's today's date. That's when the affiant submitted this search warrant, and it was signed by the magistrate judge on October 29th. So within 48 hours of that date, so that would put it either on October 29th or 28th or 27th, but not on the 26th. So this is a new event. But what does it say? That the informant this time saw a controlled substance. That's different than the first event, that the informant saw it. However, it's methamphetamine, but it says unlawfully possessed by Theta T. Reyes. Again, not by John Meyer, but by Reyes. But it doesn't say where the informant saw the drugs possessed. So did Theta T. Reyes have the drugs at 224 Majestic Grove or some other place? And since it doesn't say where the drugs were seen, even assuming this informant is a reliable person like it's claimed to be, how would that give probable cause on November 1st for the police to believe that there were methamphetamine at the residence 224 Majestic Grove, which was what was searched? But then it gets to the really incomprehensible part. It seems to me, Your Honor, and perhaps the court can see it differently, but I don't see how. It seems that what they're saying now is that they had surveillance on the residence at on Majestic Grove, and Reyes was seen at some point. It doesn't say when, but at some point they saw Reyes leave and go to an undisclosed location at an undisclosed time and engage in a controlled buy. I guess that what that means is that Reyes sold some drug. We don't know what it was. We don't know in what quantity to an undisclosed person at an undisclosed location. And then Reyes returned to the location, 224 Majestic Grove. So the problem is, where did she go? When did she go? When did Reyes leave 224 Majestic Grove? Why? When did she come back? And what happened between the time Reyes left Majestic Grove, whenever that was, and the time the controlled buy took place. It doesn't say she was surveilled or she was kept under surveillance. So we don't know if she left Majestic Grove and went and obtained drugs somewhere else, and then she sold them in the controlled buy and then returned. But fundamentally, again, particularly because it's undated and inspecific in so many ways, why would that cause anybody on October 29th, when this warrant was signed, to believe that there was drugs then, or more importantly, that there would be drugs of some sort there in Majestic Grove on November 1st when it was served? For all those reasons, Your Honor, we think that this affidavit fails. It doesn't even provide a fair probability. That's all they have to do. It doesn't even provide a fair probability that there were drugs there in the house of Majestic Grove when it was searched on November 1st. And the cases make clear, Your Honor, that the home is what it's all about. That's the Fourth Amendment is meant to provide the core protection to the home. And here we're talking about a home that was searched based on an insufficient warrant because there was no probable cause. And the courts tell us in the cases we've cited that it would be, it's wrong. This court has to carefully scrutinize what the magistrate did, because it was the magistrate's responsibility on November 1st, not to be just a rubber stamp to the police, but to serve as a neutral and detached judge about probable cause. The magistrate did not perform that function properly, Your Honor. And so now we suggest it's the court's opportunity to say that this warrant was insufficient for the reasons we've described, both orally and in writing, and that the search and the fruits of that search were all obtained illegally in violation of the provisions we've cited, namely the federal and state constitutions, which prohibit unreasonable searches, as well as Article 38.22A of the Code of Criminal Procedure and 18.01B of the Code of Criminal Procedure. This evidence should be suppressed, and we object to it, Your Honor.
State.
Your Honor, since there is a warrant, the burden is on the defense to prove the invalidity of the warrant. The Fourth Amendment has a preference for searches conducted pursuant to warrants. Defense hasn't met their burden in this case. In Illinois v. Gates, the court said that there's a totality of the circumstances approach to determine if there's probable cause determination. Standard of review that you're supposed to take in any examining court is supposed to take in these cases, judges. A deferential standard, you're supposed to show deference to the magistrate's decision. So after reviewing this affidavit, realistically and with common sense, a reviewing court must uphold the magistrate's decision so long as the magistrate has a substantial basis for concluding that probable cause existed. So, and that's the CCA Duarte judge. I believe some of the points that the defendant brought up, Mr. Stevens brought up about the number of hours. The CCA has said that 52 hours is okay. That's Swearingen v. State. 72 hours is okay. That's State v. McLean. Those are both CCA.
All right, let me stop you right there.
Yes, Your Honor.
Number one, I know the cases that you're citing, but some of them are spelled slightly different so that the court reporter can have it on the record.
I'm sorry. I'm like an auctioneer sometimes, Judge. I'm sorry about that.
All right.
So the 52-hour case is Swearingen v. State. And then there's the 72-hour case is State v. McLean.
Would you like to spell that for the court
Yes,
reporter?
sorry. Swearingen is SWEARINGIN. And then McLean is MCLAIN. It's 48 hours in our affidavit here, Judge. So I don't think there's a problem there. There's a reasonable nexus to the defendant here that states in the affidavit that the affiant states that premises are under the control and charge of John Meyer. There's some in the defendant's motion to suppress, they cite some of the case law that deals with anonymous tips, but this isn't an anonymous tip here. We have a confidential informant here. It's a totally different thing here. This affidavit does have the indicia of probable cause. I don't think it's unreasonable to rely upon this. So Judge, the last point I want to make is in the CTA and Casillas v. State, which is CASSIAS v. State, it said that probable cause to support the issuance of a search warrant exists where the facts submitted to the magistrate are sufficient to justify a conclusion that the object of the search is probably on the premises to be searched at the time the warrant is issued. And so, Judge, I think when you look at the four corners of this affidavit, when you look at the case law, this affidavit withstands scrutiny. Defense hasn't met their burden. The only other thing I'll mention is this talk about narcotics. The affidavit talks about methamphetamine, Judge. So I mean, this is not legal narcotics that the affidavit is talking about. So for those reasons, Judge, we don't believe that the defense has met their burden here. We ask that you deny their motion.
All right, so let's start with step one. Step one, defense is stating that in the affidavit for the search warrant, there's a conclusion made that premises are under the control and charge of the defendant. It just states it's under his charge and his control. The defense is arguing that that's a conclusion and there's nothing in the indictment to support, in the search warrant to support that in the affidavit. So what is state's answer to that?
I believe there's some talk here that they're doing surveillance on the house, Your Honor. And so I believe that's how they, a reasonable inference from the affidavit is that based on their surveillance, they and research in law enforcement databases, they determined that the property is under the control of the defendant.
Right, so I don't know if that's a reasonable inference or not. Because I'm looking at the second paragraph and it states premises under the control and charge of the defendant and known to be occupied by Theta Reyes. And that's it. Am I missing something?
No, you're not, Your Honor.
Is there anything else in the affidavit for the search warrant that says?
John Meyer's name
Control.
does not come up again, as I recall, Your Honor.
Well, they did see both Theta and Mr. Meyer in the house, Judge.
Where does it say that? I see nothing about that in the app. Remember, this is Four Corners.
Sure, it's at the bottom paragraph.
Okay.
Visually point out the home and verify through photos provided that Theta was a person at the location.
All right, which paragraph are you on the affidavit?
The very bottom paragraph of the first page.
Okay.
But how about under the control and charge of a John Meyer? There's nothing in there to support that. This is just like the Casillas case. And it's easy for them to do that, Your Honor. They can say, and the court's seen it, I know, dozens of times where they check the records to find out that the people they claim are living there actually do. You check property records, you can check utility records, you take 911 calls. Nothing like that was done to confirm this.
All right, so that's my question. All right, we can go off the record.
Yes.
onions that last where you don't have enough time. We have got some character letters. I gave a copy to Mr. Wilkins earlier, and they're P1 through P12.
Okay.
And I don't know if you want to read those tonight, maybe, or whenever.
I'm a quick reader, so once you all enter them, it'll
Okay.
probably take me, unless it's this thick, it'll probably take me about 10 minutes.
Okay, it's that thick.
Okay.
And then we're good. I just want to make sure that you know that they were coming, and I want you to have enough time to read it.
All right,
Appreciate
so
that.
then what will be tomorrow, guys, will, after I call the docket, then we'll start immediately thereafter. And Norma, everyone else can confer on whatever, my voice, on whatever other cases they